You may proceed.
Okay, thanks very much. It's timely that we're having this today, since this whole new regime slides in on June the 30th. It's also an opportunity for me to give you some highlights of the changes. I know that's a lengthy PowerPoint presentation, and I heard coming in from Mr. Murray that it's going to be a short meeting, so we'll take you through the highlights of this. Going into the presentation, I want to emphasize that the Peel Regional Police is really well positioned to deal with these changes in the human rights law in the province. And I think we've always been proactive in addressing any complaint coming forward in a way that we'd undertake our own investigations under inspector bond and professional standards. Those investigations would be done in a very detailed and thorough way. Because of that, I think we are better positioned than most sectors on a going forward basis because of these changes. So at least that's the good news story before we get into what is going to be an interesting new regime in human rights in the province. So June 30th, 2008 is the official launch date. Now, the new code essentially has three pillars, what's referred to as three pillars, as opposed to two previously. You've got the Ontario Human Rights Commission, along with the Tribunal, and the new entity being the Legal Support Centre. And we really see that Legal Support Centre as a form of a legal aid process to assist applicants. It all flows from the changes to the status of the Human Rights Commission, not being a gatekeeper anymore, and not being the official investigator of these complaints on a going forward basis. So one of the most significant changes to the legislation is the new role as a proactive entity on the part of the Commission. While you say that, there's still some investigative authority of this Commission, but generally speaking, it's supposed to be seen as a public promoter of the public interest in human rights issues. The Tribunal has greater powers now under the Code and remains the main adjudicator of these complaints, but also has, and we'll talk about their new power, they can direct inquiries. The inquiries can be conducted by the Commission. They can request investigations, and they have new broad powers of investigative authority, including warrantless entries into institutions such as a police service or a municipality. So having some broad authority to get in and get the documentation that they need. And that's why I said at the outset, we're well positioned because we're going to have the investigation ready to go and hopefully, prevent some intrusive measures occurring in the workplace. The Legal Support Centre, we really don't know what that's going to be until the regulations come in force, but as I said, there needs to be some sort of support for these applicants coming forward that are filing their complaints. That hasn't totally disappeared. They're not on their own, and this support centre should be giving them legal services as they go forward.
Could you just explain who's going to pay for that legal support centre?
That's the province.
And will that be to, if an officer may just say, if an officer made a complaint to them for whatever reason it might be, would they also then be covered by that, or would they be covered by their association, or how would that work?
That's a really good point. I mean, it's only the applicants that get supported by this new centre, it's not the respondents. And of course, a police officer going forward is represented by an association. So it comes down to looking at what's the basis of their claim. Is it a workplace discrimination issue? Then is it the choice of the officer to accept the legal support of this new entity? Where does the association come into play? They can step away. They can step away to a certain point from their association. I mean, that's a legal issue for them and for their agents to deal with. You see that now anyway, with officers getting their own legal counsel. From the police services point of view, we would want to make sure that the associations are aware of any human rights complaint that we're dealing with, but it's up to the officer to decide how they address their own individual interests. It sure becomes more problematic when officers use lawyers that aren't sanctioned by the association and aren't sort of within that whole model. So that's up in the air. So there are a number of significant changes, and I've highlighted a number of them in the next few slides. Essentially, the fact that complaints can now go directly to the tribunal is the biggest one. And we're trying to assess what's the impact on that going to be to the police service in terms of the intake of these. Certainly, there'll be a lot more, the gatekeeping function is gone. So we're going to have a lot more paper coming in, a lot more complaints that we're going to have to deal with at the outset. So there's not that automatic review being taken by the commission that we were quite successful on before in trying to knock out some of these. The tribunal retains some authority to look at their jurisdiction on complaints that come in, but not to the same extent as what they were able to do under the old code. So that's problematic. The limitation period has extended from 6 months to 1 year in terms of bringing forward complaints in a timely way. There's also a new statutory civil action of discrimination. That doesn't hit you as significantly as other sectors because that civil action for discrimination has to be coupled with something else. So that could be wrongful dismissal, or it could be a claim for mental distress for negligence. Very much restricted on police officers to bring civil actions. So it's out there, it's another area that we have to be aware of, but from a practical perspective, we won't really have a lot of problems with that. There's a broader area of compensation that's given to applicants under this new code, where we have restitution as well as compensation. We'll talk a little bit about that in the next slides. And that can be ordered by the tribunal, but the key to that is applicants now have an ability to make oral representations at all stages of this new process. So we'll see how that works. There's a good news story in terms of a cap. Statutory cap for mental anguish is revoked, but there's further restrictions being put on how that is established before the tribunal. I think there was a big concern about the $10,000 cap being removed and what's your liability as an employer on a going forward basis. I think the threshold is high in terms of the obligation to prove that source of harm. I referenced the other sections in this slide just to show that, again, there's an ability for applicants to make oral arguments to the tribunal to try to ensure that their complaint continues through the system. So if the tribunal looks at it and says it's beyond our jurisdiction because of a time issue or another act, applicants can have direct access to the tribunal where before it was a paper process. Restrictions in bringing decisions of the tribunal to the court system, that's a problem. We don't have the appeal rights. We have judicial review now, which is restricted. So that's always a challenge in trying to deal with decisions of the tribunal that you're not happy with. So it's given greater deference to the new tribunal. A lot more power to this tribunal than it ever has had before. Now, the Ontario Human Rights Commission, although in some of the press around these changes, is seen as having a diminished authority. If you look really carefully at this new code, there's still a lot of concerns with the far-reaching authority that the Commission has. So it's still very powerful. We can't see it as being just a proactive entity that's going to safeguard through policies the human rights of individuals in the province. There's a public inquiry role. They can initiate inquiries into allegations of infringements of rights in an institution. So how that's triggered is through a request of an individual, through the tribunal, or on their own motion. So the power to inquire into issues is really powerful. And that is also coupled with that warrantless entry into institutions and entities to gain documentation. So that's still out there. The Commission's policy development role has been broadened, and that also involves their ability to go internally into institutions to gather documentation to address that. The Commission has an ability to establish other types of subcommittees, and it's described as secretariats under the code, and I referenced one, the Anti-Racism and Disability Rights Secretariats. The mandate of those will be established through regulation, so we're waiting for that. The Commission can also bring forward issues to the tribunal. So it's not just the individual that can file a human rights complaint. So another significant change is that the Commission itself can be an applicant, can bring forward an issue that has come to their